covering this on Law and Crime for Crime Fix, talked to the superintendent of the Gallia County local schools. Yes, actually interviewed the superintendent. He was not the superintendent when the children went to, or were enrolled, I should say, in the Gallia County local schools, but he is the superintendent now and has access to information. So I thought that that was super interesting. So I might post or share some of his interview with you all because I thought it was very enlightening talking to him about just the number of kids that claim, or parents who claim that their kids are being homeschooled out there in Gallia County. So I learned a lot by talking to him. If you have been following this case, or maybe you haven't been, but a lot of people have been following this case is incredibly sad. It's curious. It's disturbing. It's just about every kind of, adjective.
This process has opened our eyes to the flaws in our justice system. For example, my wife and I being arrested for nothing more than supporting our daughter. Those words were spoken by Kim Clenney, the father of Courtney Clenney, the former OnlyFans model who just pleaded guilty to manslaughter in the stabbing death of her boyfriend Christian Obumseli, 4 years and 4 months after she put a kitchen knife 8 centimeters into a man's chest, puncturing his right subclavian artery and leaving him to bleed out on the floor of their luxury Miami condominium. Courtney Clenney's father stood outside the courthouse and described his daughter's arrest as a terrifying reality check about what can happen when government agencies are allowed to act unchecked. He was talking about his own arrest for unauthorized computer access, charges that were later dismissed. But his words encapsulate something far more disturbing about this case. The family of a woman who admitted to killing her boyfriend believes they are the victims, and the criminal justice system, in many ways, agreed with them. Before we go deeper into what the documents actually show, make sure you're subscribed to Endless Crime, because we don't just cover the story, we follow the evidence. Picture this: you are standing in a Miami courtroom on August 10, 2026. The air is cold, the fluorescent lights are buzzing. In front of the judge sits a woman who was once a successful OnlyFans model, earning thousands of dollars a month from subscribers who paid to see her body. Now she is wearing a jail-issued jumpsuit. Her hair is different. Her face is different. 4 years of incarceration have reshaped her, and she is about to say the words that will change the rest of her life. She is guilty. But here is where the frame freezes.
The case this week, and when I say developments, I don't mean additional criminal charges being filed aside from the 16 child endangering charges that they face right now. But there have been some new developments, and we're going to talk about those right now. Also, if you guys would give a thumbs up on the video too, that would be really helpful because that helps the video in the algorithm. Also, if you're watching on replay and joining on replay, thank you so much for doing that. I really appreciate it. So just love it. Love that everybody's tuning in and wants to hear me talk about these cases. For those of you who may not have been following this closely, I'm not going to do a ton of background on it because I know people get a little frustrated with some of that, but I just want to give you everything that I know about this case and make sure that everybody who's tuning in, whether they're tuning in for the first time or not, knows what's going on with the case, because maybe not everybody is following it. But 4 members of the Siders family currently face child endangering charges in the state of Ohio. They live in Vinton County, Ohio. That is a county in the southeastern part of the state. It's a poor county. It's the least populous county in Ohio. Ohio has 88 counties, if you can believe it. It's a lot of counties. And Ohio is a pretty big state. You might not realize that, but it is a fairly large state. And you get a mix of just about everything, bigger cities, suburbs, rural communities, more Appalachian communities in the east and southeastern part of the state. So you get a good mix. And so this is a family that was initially from Gallia County in Ohio. And it appears in around 2020, 2021, somewhere in there, they moved up to Vinton County, one county north, which is the smallest county in the state, one of the poorest, if not the poorest county in the state. The county government has an operating budget of just $8 million a year.
because what she is pleading guilty to is not murder, it is manslaughter, and the sentence she receives is 6 years. She has already served 4, which means if she behaves, Courtney Clenney will walk out of prison in roughly 2 years. That is the image. That is the visual anchor of this entire case. A woman who killed her boyfriend will serve less time than many people serve for drug offenses. And her father stood outside the courthouse and blamed the government. The relationship between Courtney Clenney and Christian Obumseli began in late 2020. The factual proffer read into the record during the plea hearing described their relationship as extremely tempestuous and combative. Both had been involved in numerous domestic violence incidents. They moved to South Florida in January 2022, taking up residence in a condominium at One Paraiso in Miami's Edgewater neighborhood. During the 3 months they lived there, management received so many complaints from residents and security staff about the couple that eviction proceedings had already begun.
All facing child endangering charges after police, I should say the Benton County Sheriff's Office and agents with the Ohio Bureau of Criminal Investigation went to a home in the village of Hamden where this family was living back on June 30th. They went there armed with a search warrant. Okay, they had a search warrant separate from an arrest warrant for Gary Siders Jr. up in the upper left-hand corner there, the younger man. They had a warrant for his arrest for 4 misdemeanor counts of public indecency where he was exposing himself. That's the allegation, the accusation that he was exposing himself on 4 different occasions starting on May 23rd of this year, going to May 31st of this year. What I think is interesting about that is that May 23rd was the Saturday of Memorial Day weekend. So that would have been a 3-day weekend. Did this potentially involve children? I don't know. Kids off school riding bikes? I don't know. It's just a thought that has crossed my mind. We have no idea why the cops went there with the search warrant. It appears to be separate. I know people have said, but the release on the sheriff's website said allegations of domestic abuse and this, that, and the other. That said that, and it was actually a press release from the Attorney General's office. But on that same date, the press release the Attorney General's office sent out did not include that information. And it was authored by the same person. So I don't even know if that is accurate. That could have been edited and later sent out. And this may have nothing to do with allegations of domestic abuse. Okay. We just don't know yet. But the investigation is ongoing. They go in there with the search warrant looking for evidence of a crime not related that we know of to the public indecency charges. And they find 16 kids. And they have to go get a second search warrant for the 16 kids because they've walked into the house and they're like, holy smokes, what is going on? There are 16 kids in one room. Oh my God. They get the kids out of there. They take them to the hospital and they've got a child endangering case on their hands. So they then have to go get another warrant because the warrant they originally went there with didn't cover the children in investigating a crime related to child endangering. So there were 2 different warrants executed at this home back on June 30th.
Neighbors heard screaming. Security responded to disturbances. The couple was, by all accounts, a disaster unfolding in real time. On April 3rd, 2022, that disaster reached its terminal point. What actually happened inside that condo that night has been the subject of 4 years of legal warfare. Courtney Clenney's version has shifted, but the core claim remained consistent. She acted in self-defense. According to her attorneys, Christian attacked her, threw her against a wall, choked her. She grabbed a knife and told him not to come near her. He charged at her. She threw the knife. It hit him in the chest. She never meant to kill him. She was terrified. She was the victim of domestic violence. The state saw it differently.
Make her legally, under the law, insane at the time that these offenses occurred, meaning that she was so mentally ill at the time that these child endangering charges happened that she didn't understand what was happening was wrong. So I'm going to pull up that motion and show it to you because there are a lot of questions here that we don't have the answers to. We don't know why they first went there, what evidence of what crime they were looking for. We know that this is Elizabeth on June 30th of this year. Look at her. This is Elizabeth several years ago on her mom's Facebook page. Back in 2020, this is an undated photo. This is Elizabeth with her mom wishing her a happy birthday. So, how did Elizabeth Siders go from this looking well, blonde hair? I mean, she's a pretty girl to this. What on earth happened? What went wrong? Aside from her giving birth to 18 children over 18 years. I mean, that's enough to wear anybody out, right?
Prosecutors described Christian Obumseli as a victim of domestic violence, not the perpetrator. They pointed to evidence of Courtney's aggression toward him, including videos showing a pattern of violence. They noted that Courtney called her mother before calling 911. They noted that she called building security before calling 911. The third call, the one that should have been the first, was to emergency services. By then, Christian was beyond saving. The medical examiner determined that the knife penetrated approximately 8 centimeters into Christian's chest, puncturing the right subclavian artery. He bled out. The wound was fatal. There was never any question about who caused it. For more than 4 years, Courtney Clenney maintained her innocence. She was arrested in Hawaii on August 10, 2022, 4 months after the stabbing, and charged with second-degree murder. She remained in custody without bond. Her legal team fought every step of the way. They tried to have the Miami-Dade State Attorney's Office removed from the case. They sought to introduce evidence of battered women's syndrome, lining up experts including Dr. Lenora Walker, the psychologist who first defined the condition.
Alternatively, if the defendant is found to be competent, counsel hereby simultaneously requests that the defendant undergo an evaluation to determine if she is not guilty by reason of insanity, because she was suffering from a condition which would produce legal insanity at the time of the alleged offenses. Defense counsel makes this motion in good faith to determine defendant's mental condition at the time of the offenses charged and whether the defendant is competent to stand trial on the offenses charged. The reasons for this motion are more fully explained in the attached memorandum in support, which should be incorporated herein. So let's take a look at his memorandum in support. Now, keep in mind, this comes after the defendants, the remaining 3 defendants, the other 3 defendants have already asked for competency evaluations. I was kind of like expecting this and wondering why hasn't he filed for one of these? I mean, is he still meeting with her and just kind of sizing up the situation, seeing how she comes across? Why is Tommy Stolle not filing for this? It seemed like everybody else had questions about the competency of their client or are laying the groundwork for a mental health defense. And then boom, he did it this week. Counsel was appointed on July 2nd to represent the defendant. Okay, we can move past that. On June 30th, the defendant was charged. We already know that. As of the filing of this motion, the defendant has not been indicted, and therefore counsel does not have all of the facts, evidence, or circumstances of this case or the defendant's subsequent arrest. However, in the interim, counsel has met with the defendant on numerous occasions and for extended periods. So he's saying he's met with her on numerous occasions and for extended periods. So I'm assuming that means several hours, many hours. He spent a lot of time talking with her, trying to gather information and trying to figure out what in the heck was going on in this house on Omer Street, in other houses where this family lived, and from the time that she married into this family at the age of 15, which is still just boggles my mind.
They argued that the evidence would show
during these interactions, counsel has been able to observe the defendant's demeanor, conduct, and comprehension. These interactions lead counsel to believe that the defendant may be suffering from significant mental health issues and that competency may be an issue and a clear impediment to the defendant's ability to assist in her own defense. Counsel is prepared to provide a more detailed accounting of his concerns and the specific conduct giving rise to those concerns directly to the court and eventually to the evaluating medical professionals. So he's saying directly to the court. He's signaling, I'll let you know what I'm talking about, Judge, but I'm not handing this over. It doesn't sound like he wants to hand this over to the prosecutor. It doesn't sound like he wants to file this information publicly. So there are ways for, defense counsel and even prosecutors to disclose information to a judge without sharing it with the other side. Like I've seen it happen in death penalty cases where the judge meets with defense counsel to discuss like, okay, we need this money for this and that. And it's to keep it so, the prosecution isn't like, hearing about their strategy and things of that nature. But typically, it's pretty standard that you would file this information and then it would be turned over to the prosecutor as well. It'd be shared with them because you don't want to engage in a bunch of ex parte communications and stuff like that. It's just not proper. So he's saying, I'll give it to you, judge, but I don't want to file it publicly. Well, of course, we all want to know what's going on. We want to know what he's talking about. What have you observed that is so concerning to you? I'm wondering if Elizabeth, because he had previously said in an interview that she said that all children are blessings from God, that she was open to having a large family. Is it possible that Elizabeth, I mean, who knows if she really wanted to have 18 children? I can't imagine a woman saying who doesn't have the means to do it, wanting to have, all these children, like, especially when you can't care for them. Like, how on earth can you actually care for 18 children, provide for them, and actually like pay attention to them? Like, you just don't have the bandwidth to deal with all that. You would have to have help, a lot of help, I believe. And so I'm wondering, is she saying to them, like, or saying to Obumseli, like, yeah, I really like this. I'm on board with having all these kids. Like, I love all my children. I mean, of course she loves her children, right? But I'm wondering, is she saying like, yeah, I wanted to have all these babies and and he's like, what? Oh my God. Like, I mean, I'm wondering if what is she saying that is so concerning to him that's really making like the hairs on the back of his neck stand up for him to file this motion and say, I'll tell you, judge, but I'm not telling everybody else. At this time, counsel believes that the defendant's significant mental health issues would not only affect whether she is competent to stand trial, but would also have affected her ability to understand the wrongfulness of her conduct at the time of the alleged offenses, such that the defendant would not have fully understood the consequences of her action at the time of the alleged offenses, should such actions have actually constituted criminal conduct. Wherefore, counsel for the defendant respectfully requests that this order Wherefore, counsel for the defendant respectfully requests that this court order a formal evaluation to be conducted in order to determine both whether the defendant is competent at this time to stand trial to the offenses as charged herein, and if so, to further evaluate the defendant to determine whether she is not guilty by reason of insanity because she was legally insane at the time of the offenses. So that is what Obumseli said. He is seeing things that concern him greatly for his client. Is he just kind of following the playbook that everybody else is? Is he just kind of falling in line with the anticipated defense here? I mean, I could totally see all of these defense attorneys talking together behind the scenes and saying like, yeah, we don't really have much going here, even though we don't have the discovery. We know this is child endangering. They're living in squalor. Nobody's taking the kids to school. Like, we've got all that, even though the prosecution is not coming to them and saying, hey, here's all this discovery that we've gathered. They've probably gotten minimal discovery thus far because the case is going to go to a grand jury. And then after it goes to a grand jury, they can, file whatever and request all these demands for discovery, give us everything. But right now it's still in the phase where that hasn't happened that we're aware of. Maybe that process has started, the grand jury process, but we really don't know.
Courtney was the real victim. that Christian had choked her, that she feared for her life, that she threw the knife in desperation. Christian's family rejected that narrative completely. His mother, addressing the court after the plea, described the call she received on April 4, 2022. The day after her son died, she was at work when someone from Miami asked for consent to donate her son's organs. She had spoken to him the day before. She had no idea he had been killed. That was the darkest day of her life, she said. 4 years later, there are still nights when she cannot sleep. There is simply too much pain to put on paper, she told the court. No sentence, no plea can bring back my son to me. Christian's family also revealed something that cuts to the heart of this case. Christian had previously been cut in the face by Courtney. He had previously been stabbed in the leg by Courtney, and he had written that his love for her would eventually get him killed. He predicted his own death at her hands. He stayed anyway, because he loved her, and that love, his family said, was what killed him.
If they go for that, it's going to be very, very, very difficult, as Dr. Bober said. Proof that a person's reason at the time of the commission of an offense was so impaired that the person did not have the ability to refrain from doing the person's act or acts does not constitute a defense. What does not constitute a defense of not guilty by reason of insanity? Proof that a person's reason at the time of the commission of the offense was so impaired that the person did not have the ability to refrain from doing the person's act or acts. That does not constitute a defense. So she's got a tough hill to climb if she's going for that, because you obviously know when your kids are sick, right? If my kid's sick and the cops come in my house with a search warrant and they find my kids and one of them needs to be intubated, and they have said that one was so sick they thought if they'd gone another day or two the kid would have died. You know, if your kid's sick, take your kid to the hospital. Take your kid to the ER.
A chair where a family gathers for holidays will always remain empty. That is the refrain. A chair where a family gathers for holidays will always remain empty. A chair where a family gathers for holidays will always remain empty.
So I think he wouldn't tell me. Philip Kuhn, he's the superintendent of the Gallia County Local School District. He wouldn't and couldn't tell me just how active the children were in the online schooling in the 2020-2021 school year, but he said they were definitely enrolled in the online school. It's called like the Southern Ohio Digital Academy. Following year, 2021-2022, they never show up for school. So then I'm like, okay, so were they enrolled prior to the 2020-2021 school year? He said, no. They weren't. The kids were not enrolled in school prior to the 2020-2021 school year. Okay, well then where were they enrolled? So I'm like, where were they enrolled? And why did they suddenly enroll in 2020? Why? What happened? I'm like, is this when, because when I first started covering this story, I was told that CPS, Children's Services, it's Job and Family Services, or the Department of Youth and Children, or, you know, whatever they call it now, had been in touch with the family, had some contact with the family. Was the family basically forced to enroll the children into school? This is my thought. I'm wondering this. I haven't confirmed that, but I'm wondering this. Like, was it like, you guys got to get your kids in school? Like, what are you doing? You know, Elizabeth's having all these babies.
The plea agreement that brought this case to a close was, by any measure, a remarkable piece of legal engineering. Courtney Clenney was facing second-degree murder, which carried a potential sentence of up to 30 years in prison. Her original guidelines under that charge were well above 20 years. Even after the charge was reduced to manslaughter with a deadly weapon, the guidelines called for approximately 10 to 12 years. The state agreed to 6. She had already served 4. With good behavior, she could be out in 18 to 20 months. Let that sink in. A woman who stabbed her boyfriend to death, who admitted in open court that she was the cause of the fatal wound, will serve roughly 2 additional years in prison. 2 years for a death. The state's justification was pragmatic. The case was difficult. The evidence was complicated. The relationship was toxic on both sides. The family wanted closure. A plea deal guaranteed accountability without the risk of a trial. As State Attorney Catherine Fernandez Rundle put it, with this plea agreement, Christian Obumseli's family finally heard what they long sought. Courtney Clenney accepting full responsibility for his death. But here is where the forensic examination becomes uncomfortable, because accepting full responsibility and serving 2 additional years are not the same thing. And the family's approval of the deal does not erase the fundamental question: why did this case resolve the way it did? Courtney Clenney's defense attorney, Frank Prieto, offered a blunt answer. The evidence in this case would have been overwhelming at trial on the side of the defense. He said, but you never know what a jury's going to do. He cited the risk of trial, the unpredictability of jurors, the possibility that a jury might not like him. He framed the plea as a calculation 20 more months versus the uncertainty of a trial that could end in acquittal or conviction. The state's case crumbled. He claimed, that's why we're here today with the sentence. His co-counsel, Sabrina Puglisi, emphasized that the defense had evidence of domestic violence that would have been presented at trial. Independent witnesses, including a neighbor who saw Christian hitting Courtney, medical records documenting injuries, experts on battered women's syndrome. Resolving this case is not a retraction of the truth. She said, Courtney Clenney was the victim of domestic abuse. The state, however, described Christian as the victim, and the evidence of Courtney's aggression toward him complicated the self-defense claim significantly. The truth, as is often the case in these situations, was probably somewhere in the middle. A toxic, violent relationship. 2 people who hurt each other. One night when the violence became fatal. But here is the ticking clock moment. If Courtney Clenney was truly acting in self-defense, if she was genuinely terrified for her life, if she threw that knife because she believed Christian was about to kill her, then why did she wait to call 911? Why did she call her mother first? Why did she call building security before she called emergency services? And why, after 4 years of insisting she was innocent, did she suddenly plead guilty just weeks before trial was set to begin? Was it justice? Or was it a calculation? This is not a rhetorical question. This is the central mystery of the entire case. Courtney Clenney had a defense that, by her own lawyer's admission, was strong enough to risk a trial. She had expert witnesses. She had evidence of abuse. She had a narrative that could have resonated with a jury. And yet, she chose to plead guilty to a reduced charge, accepting a sentence that, with time served, amounts to roughly 2 more years behind bars. Why? Because the alternative was 30 years. Because the state had evidence of her aggression. Because a jury might not have believed her. Because the risk was too great. Because, in the end, the plea deal was the safe bet. And that is the uncomfortable truth that this case exposes. The criminal justice system is not always about justice. It is often about risk management, about calculations, about what can be proven, not what actually happened, about what a jury might do, not what the evidence might show. Christian Obumseli is dead. Courtney Clenney will be free in 2 years. And somewhere in the evidence file of this case, in the medical records, in the video footage, in the witness statements, in the factual proffer read into the record on August 10, 2026, there is a document that holds the key to what really happened that night. There is a piece of evidence that explains why the state agreed to this deal. There is a reason why a woman who stabbed her boyfriend to death will serve less time than many people serve for drug offenses. That document is public record. It is available to anyone who wants to look, and it raises a question that only you can answer. If Courtney Clenney had been a man who stabbed his girlfriend to death, would he have received the same deal? 4 years of litigation, 4 years of waiting, 4 years of a family grieving a son, a brother, a nephew, a friend. And in the end, a plea deal that gives the family a measure of closure but leaves the deeper questions unanswered. Christian's mother said it best, "Today closes a legal chapter, but it certainly doesn't close our grief. The legal chapter is closed, the grief is not." And somewhere in the Miami-Dade court records, the truth about what really happened on April 3, 2022 is waiting to be found. If you found this analysis valuable, like this video, share it with someone who needs to understand how the justice system really works, and subscribe to Endless Crime so you never miss an evidence-based breakdown. Turn on notifications, because we don't just cover the story, we follow the evidence.